Welcome to The Heart of the Matter, a podcast that covers legal developments from around the world. I'm your host, Stephen Lai. This podcast is brought to you by Conventus Law. In this episode, we'll be talking about the data localization rules of Vietnam. Joining me on this episode are lawyers from Vietnam-based law firm Russin Vecchi, Nhut Nguyen, and Viet La Tong. Before getting to the heart of the matter, a message from our sponsor, who generously supports this podcast.
Ashford Benjamin was founded with the belief that search firms should offer a better service to clients and candidates. This means taking the time to provide a genuine partnership, understanding our clients' and candidates' needs, and proactively advising on the best course of action, utilizing the decades of experience in our industry specialisms, including risk, compliance, business and legal recruitment consultancy, located in central Hong Kong, serving Asia Pacific.
Hello, Nhut. Hello, Viet. Welcome to the show.
Hi, Stephen. Nice to meet you again.
Hi, Stephen. It's great to be here.
In this episode, we'll be covering cybersecurity regulations in Vietnam. The idea of this episode is to get a better understanding of data localization rules in Vietnam, and it's great to have you two on. I'm going to kick off with you, Nhut. Cybersecurity legal framework in Vietnam. I understand there's been some new data localization rules called a Decree 53. Can you just tell us the significance of this new rule?
Before we delve into the relevancy of these new rules, let me just give a broad picture of the cybersecurity legal framework in Vietnam. Well, historically, regulations and laws on cybersecurity activities were scattered, very scattered in various laws. The two major laws were the law on network information security, dated back in 2015, and the law on IT, information technology, dated back even further in 2006. But then, in June 2018, the National Assembly of Vietnam passed a new law called Law on Cybersecurity, effective in 2019. And the idea was to sort of unify the legal framework and provide a comprehensive framework for activities relating to the cyberspace in Vietnam. And the law at the time when it came out, it introduced a lot of new concepts, broadly cast. And one of the things is the law alluded to the possibility of data localization, or localized storage of data in Vietnam that could affect many operators on the cyberspace, and that has caused a lot of controversy. And now, the Decree 53 talks very specifically about data localization, and it clarifies the mist.
Yeah, I think you, before we go into the details, you should understand the structure of the legislation in Vietnam. Being a law, the law on cybersecurity is often drafted broadly, with the expectation that there will be guidance later on in the form of decree or circular or other supporting documents. So the Decree 53 will act as one of those documents. It will explain what type of data is regulated, how long must a subject store the data in Vietnam, and so on and so forth. And there will be another decree coming out, which will provide the enforcement framework, so the violation sanctions. But that should be another discussion. I think we can move on to the first part of Decree 53, which is to say which type of data is regulated. There's nothing new in this section, because most of the data provided in Decree 53 was already provided in the law on cybersecurity. They just put a different word to it. So Decree 53 regulates three types of data. One is personal data of Vietnam-based user. Two is data created by Vietnam-based user. And three is data in relation to the relationship of Vietnam-based user to their friends and other people that they interact with. I think it's important to understand like the concept of Vietnam-based user provided in this decree, which is defined to be like entities or the individuals using services in a network environment. So, for example, if we are using Zoom right now, I and you should be Vietnam-based user of Zoom. It should be noted that like while the decree concern personal data in its scope, it does not provide any obligation in relation to the protection of such data. The protection of personal data will be regulated separately in another decree on protection of personal data specifically, which interestingly enough also includes a requirement that data processors must store the original copy of the personal data in Vietnam.
So what you're saying is Decree 53 will cover personal data, but you're saying there's going to be another decree that's going to have a more detailed section on personal data. Am I right?
Right, yeah.
Okay.
Yeah, so basically, Stephen, Decree 53, the data localization rules, just looks at personal data. It doesn't talk about privacy and stuff. But
Right.
then when it comes to data created by Vietnam-based users, information that is regulated by Decree 53 is like, covers personal data like, email address, even credit card information. Those kinds of information will be subject of Decree 53 in terms of where the data should be stored and in what circumstances they should be stored.
Yeah, so it's about where the data is stored. This is where it gets complicated, right? Because how wide reaching would this law be? Because if I'm running a business, say in Hong Kong, and I happen to have Vietnamese customers who are buying things on my site online, and I have their data, am I bound by Decree 53?
That was the concern back in when the requirement was first introduced in the law on cybersecurity, because back then is the law just say like companies that have Vietnamese customers must store data in Vietnam and have like a physical establishment here in Vietnam, which is not like possible for all of the foreign enterprise, right? So the Decree 53 shed some light into that requirement. It says, so like it still say that Vietnamese enterprises and foreign enterprises must are subject to the requirements, but it added some criteria. So for foreign enterprises will only be subject to Decree 53 if the business in certain fields, certain businesses. So, like for example, telecommunication services, data sharing and storage, online games, e-commerce, social network. I'm sure if you look at the text of the Decree 53, they will have like a comprehensive list. The second criteria is that somebody must be using the services provided by the enterprises to violate the law on cybersecurity. So, like for example, to spread lies against the government, or to raise a riot or something. And the third one is that the government must have already requested the company to take down the service against the law on cybersecurity, but the company fails to cooperate with the government. So like when the government go back a second time, in that case, the government will request that the company store the regulated data in Vietnam.
Right.
Yeah, so that's the that's the myth and misperception, I should say, when people first look at the law on cybersecurity a few years ago. And Decree 55 clarifies and sort of clears the mist in the sense that, for example, Stephen, in your example, you're doing business in Vietnam. We are your Vietnam-based users. You don't automatically come under the radar of Decree 53 unless we or somebody in Vietnam use your services to violate the law, and the government has come to you and said, well, look, you have to do something to stop this. Otherwise, you have to bring your data in Vietnam. That's how the localization rules now apply to foreign companies sitting outside of Vietnam but reaching Vietnamese
Right.
users.
Right, it makes sense, right? Because I think the world we live in now is very globalized.
Exactly, yeah.
And the way we do business is very much, you don't even have to be in that country now. I guess it's an attempt to codify the rules of how to do business in the cyberspace for Vietnam. But so I'm thinking, so the first industry I'm thinking of is social media. Then would I be right in saying if I'm running a social media site that is very popular and people are coming on, and obviously they're spreading, people are spreading rumors about something or spreading lies, does that mean that particular social media network or any social media network has to have some sort of data presence in Vietnam? Then would that be correct?
Basically, no, but it can be. So the way Decree 53 works is that, for example, in take the example you just provide for. So we will discuss it. So, for example, you have a social media, and people spreading rumors on it, and the government say that these rumors are not acceptable and are in violation of the law. The government will go to you and say that take down the account spreading rumors. You have to delete the rumors, and you can at that point choose like whether you take them down or you don't. So if you don't comply with the request of the government, and the government will go to you again, like in the second time, and it will say that you did not comply with our request, which caused like some sort of damages that they provide, and in the second request, the government will then ask you to say that because you didn't comply with our first request, you are now subject to Decree 53 and you must store the data in Vietnam.
Right. So you get a warning shot, so to speak.
That's right. And if you cooperate, things will go back to normal.
Right.
And if you don't, then
because even if you are requested to store the regulated data in Vietnam, you don't have to store it in Vietnam forever.
Right. Well, I was going to ask you actually. So the next question: what is there a time limit then? If you know how long are companies required to store the regulated data in Vietnam, and with Decree 53, is there going to be a grace period for this, or is it immediate? Viet.
So the Decree 53 only say that in the government request saying that you have to store the data in Vietnam, the government will say how long you must do that. And the minimum storage period provided in Decree 53 is 24 months, 2 years. Okay. And it starts from when you receive the request to store the regulated data. However, the Decree 53, it does not say anything about a grace period. It does provide that companies will have a 1 year period to establish the presence in Vietnam, so like to set up a subsidiary or a representative office in Vietnam. But regarding the storage of data, it doesn't say like you have any time to do so. I guess that in the request, the government will say that you will have some time to do so. I think one of the saving grace of Decree 53 is that it gives the discretion to the company on how they store the data in Vietnam. So you can choose to have a third-party server in Vietnam or set up your own servers here in Vietnam.
Mm-hmm. Must be great business for the server farms, huh?
Yeah, I think that's true. I mean, people are talking about data centers now. I mean, and the forecast, the prediction is that going to be booming if these data localization rules that kick in.
Yeah, well, that's great. It's codifying some complicated issues, and it's also good for the domestic economy. So it sounds like a win-win to me.
Yeah.
um,
Sure.
so back to Viet. If I'm a foreign company doing business in Vietnam, what tips do you have for them then to make sure you're compliant with these new rules, the Decree 53?
I think one of the general umbrella rules is that you should pay attention to the laws, especially in this in late 2020 and 2022 and I think early 2023 there are a lot of new regulations coming. So for example, we have the Decree 53 and we have another decree on administrative sanctions for violation of the law on cybersecurity, and there will be a decree on personal data coming soon. And potentially there can be a law, even a law on personal data protection. So that is one of the general rules I think companies doing business in Vietnam should take note on. However, more specifically, I think companies should practice data classification. So like they should categorize the information collected based on various criteria. So for example, based on sensitivity, based on whether the data is subject to any regulatory requirement or not. I mean, I think a lot of company has already do this, but just to be sure, companies should be aware that not they do not have to store all of the data in Vietnam. They just have to store specific data in Vietnam. Another thing is that companies should keep a log data of how data is accessed, like from the access time, the access location, because one of the under Decree 53, the log in some circumstances the government may request a log data and may require that the company kept the log data for at least 12 months in Vietnam.
In terms of businesses, obviously needing to be compliant in this space, it doesn't sound like there's too much additional costs. I'm assuming these companies are already paying for, data servers somewhere else. But if it means that they have to transfer a percentage of it to Vietnam, data now is charged by I guess by memory, right? So they just offset the cost for wherever they are to Vietnam. But it does sound like the thing that they do need to work on is either do it in-house or seek advisory services to really just work out what is required of them. And then once they work that out, it sounds pretty straightforward. Would that be a fair assumption?
Yeah, I think at this point, companies should be prepared, but they should not hastily do anything. So they should not even contact a Vietnamese server, for example, to preemptively store the data in Vietnam, because that would introduce additional cost into their business.
Right.
At this point, that they should prepare. So when they are requested, they can comply with it within the time frame provided by the government.
Right, I see.
I think one of the more important points that they should inform the clients of these obligations, because some clients may be reluctant to store data in a specific location, and also because whether a company is subject to the requirements of Decree 53 also depends on the clients. They don't use the service of the company to violate the law, or so when the government comes in the first time, the company can already comply with the government to avoid having a second request of the government saying that you need to store the data in Vietnam.
Right. Now I know you guys have got a lot of tech clients at your firm. Are you getting a lot of queries about this now? I mean, are the companies paying attention to this?
Yes, we do, and this is becoming more and more relevant in our regulatory advice practice. yeah, I mean, tech companies have raised concerns, and they try to understand better the regime. Companies doing marketing researches, for example, because they collect a lot of data. Yeah, and all sort of people involved in the social media and social networks. I think are very interested, have a great interest in the new rules, and I think it's a developing area of practice for tech lawyers like us, and also like you mentioned earlier, Stephen, for people who prepare to get data in Vietnam and store them for in data centers and all of the storage services.
It does certainly make sense. I think the current trend is if I'm looking at all the different countries' data and privacy security, so looking at all the different countries around Asia's development on data and cybersecurity laws, it's a bit like whack-a-mole. One week I'm hearing about Vietnam, the next week is something in Thailand.
Yeah.
In India ramping up theirs now. China did it last year. Hong Kong did it last year. So it's just a continuous thing going on. So it's certainly not boring. I could say that. So, but with that, Viet and Nhut, thank you very much for your time. Time's up for this episode, and I appreciate you sharing your knowledge with us about the new decree. Thank you again.
Thanks, Stephen. Great to be on the show again. Yeah, and we'll speak on another episode soon. Okay.
Thank you, Stephen. It's great talking to you.
Thank you, guys. And thank you, listeners, for listening. I look forward to talking to you on our next episode.